All right, folks, well, let's get started. Today, we're going to do a Q&A, and thank you for those of you that submitted questions. We've got several of questions that are really good, actually. I'm excited to talk about them. A couple ground rules as you come in. I'll keep everyone on mute so that we can keep the background noise to a minimum since we're recording this, and we'll be sending this out to any of your friends that didn't get a chance to get some of these answers from our Q&A. At the end, because I like to keep this about 30 minutes, but at the end, if you have any additional questions, let's have you use the chat to ask those questions so that we can avoid talking over each other. I know I'll continue to add some more people as the latecomers come in, but I think that will work out nicely. But I'll get started now. As you all know, I love to start out with stupid laws. I couldn't help but see a couple of new ones that I thought I knew about, but apparently I didn't. And I don't think I've ever shared these with you. So laugh away. The first one is in Colorado. We're going to pick on Colorado today. They changed a few statutes in Colorado that I think are pretty stupid when it comes to associations last year. So I looked at them. First of all, this one's crazy. It's stupid, but at the same time, I think it's genius. And I wish Arizona would do the same thing. And you'll agree with me after you hear it. It is against the law for children over the age of 8 to wet the bed. I think that's fantastic because, you know, I've got 5 kids. I don't know about many of you. You probably all have, many of you've got kids. It would have been great if we had this law in place. The question I have, though, is, okay, my 9-year-old wets the bed. What do we do about that? We can haul him off to jail? It's pretty funny. And whose bed was wetted? It had to be either the mayor or a lawmaker or somebody with some political clout to actually codify this in Colorado. It's nuts. Okay, here's another one. This is a funny one. Again, somebody pissed off, somebody with some political clout. So we have this now. In Denver, it is illegal to stutter on a Sunday during a church service. So I don't know if somebody was giving a prayer or somebody was giving a speech or somebody couldn't spit out amen, brother, or amen, sister, but somebody got pissed off. So if you're in Denver and you go to church services, do not stutter. All right, last one, then we'll dive right into these questions. Cats that meow in the dark will have their tails chopped off. So a question came in on the chat. Where are you finding these crazy laws? Well, it's a great website, actually. I go to stupidlaws.com and then I type in on the state. And the nice thing about this is I can actually see the language that's used. So I look at the summary, but then if I want to click on the hyperlink, it takes me right to the actual law with the verbiage. So anyways, we'll end there for now, and we'll just get right into our questions that you guys submitted. All right. Here's question number 1. This was a question in no particular order, by the way. I'm not going to mention the manager. If you want to, in your chat bar, say that's my question, it's your prerogative, but here we go. Does the board liaison to the architectural committee have to be present for the committee to review business? It's a great question. Some of these, there's going to be an easy answer. Some of them, it's our favorite, it depends. I'm going to give you an if-then because it depends. You just hear time clicking away and money for an attorney when you hear it depends. But with an if-then, you walk away at least feeling satisfied you have a baseline. If your documents are silent, then, and if this is an issue for your community, I don't think, there's nothing in the statute, there's nothing in the case law that says that the board liaison has to be present. Why? Because the statute itself, if you look it up, it only says that the board member shall chair the committee. It doesn't say shall chair the committee meeting. It doesn't use the word meeting. Now, the argument here could be at the very top of that same statute for both the Condo Act and the Planned Community Act, it says meetings specifically for committees. If they're regularly scheduled, they're open to the open meeting laws, right? If they're regularly scheduled, it says regularly scheduled meetings. But they leave out the word meetings when it comes to the board chairing the committee. So the argument here from our judge's standpoint would be what's called strict contextualist. There are some judges that are very strict as to the actual language used, and there's a legal doctrine that says if you include a word somewhere in the statute, but you exclude it everywhere else or somewhere else, then that word doesn't apply at that other spot. So that's the argument, is because the statute uses the word meeting for regularly scheduled meetings, but does not use the word meeting when it talks about the board chairing the committee. The argument is you don't need to actually have them there present at every meeting. Is it a good idea? Absolutely. I'm the chair for our architecture review committee in my office condominium, and I'm not there for every meeting, but frankly, we don't really have meetings because they're not regularly scheduled. So that's the next question. If your committee is meeting regularly, that has to be open. We know that. And then it needs to be, the decisions need to be made and decided on. But if you don't have regular meetings, if everything's ad hoc, like in my scenario, where manager gets the applications from our unit owners, whenever they get them, they forward them off to the ARC, and we then make a decision. I don't really have to be present at all, and there's not really a meeting, so this is a moot point. Okay, so my opinion is the chair does not need to chair the actual meeting every time, and they can delegate that to someone else if they're going to be absent, if you are actually having meetings. The caveat here is we don't have case law yet, so it's open to argument. There's a reverse argument as well. And until we get case law on the issue, I guess some judges would say otherwise, but I think the majority rule here is no. That's the best I can get because we don't have case law on this. The next question, however, does have the statute expressly address what's going on, okay? So the next question that we have, there's a couple questions here. Let's take a look. All right, so a couple of these questions I'll get back to. Well, here's one of them. Do you offer seminars that qualify for CAI, CLEs, or your continuing education credits, specifically for CMCA? The answer to that is yes. There are several old classes that we had pre-pandemic that are all CMCA approved. And good news is Mark Holmgren, my partner, is doing a class next month, so that when you attend these, they're for CMCA credit. We have to get them approved in advance. His discussion is going to be on construction issues, maintenance problems, that kind of thing, since his expertise is not only in the litigation world, but construction defect. So absolutely, yes. We know that that's a big want for all of you to get your CMCA credits. And so our plan is to have the next one approved for CMCA. Unfortunately, this one is not, because it was all question and answer for you as managers. So we couldn't put that together and submit it to CAI in time, because we've been getting questions for this up until actually a couple of days ago. So very good. Okay, going back to the next question. I currently have an owner who is reporting that their next door neighbor is growing marijuana in their backyard, and in the summer it smells horrendous. I know Proposition 207 allows people to grow and use for personal use, but can they grow it outside in their backyard? And what can the association do about it? Very good question. This Prop 207 did say that you can't do anything to prohibit personal use. So what does that mean for the association? Let me summarize. One, no, they cannot grow it outdoors per the statute. Nice to have a clear answer. Here's why. The new law, which by the way is ARS 36-2852. The new law allows for individuals that are adults, 21 years of age or older, to quote, cultivate not more than 6 marijuana plants, six, not 7, 6 marijuana plants for the personal use at the individual's primary residence, or a max of 12 plants at a single residence. But here's what happens with the actual cultivation. The statute addresses this. Here's the most important part. The cultivation has to take place, quote, within a closet, room, or other enclosed area that has a locked or security device. So that basically is required to prohibit access by minors or to keep it visible from public view, okay? So the key operative language here is it has to be in an enclosed area within a closet, room, or other enclosed area and under lock and key. Now, we've heard from some people and some owners arguing over this that, well, my backyard's an enclosed area. Yeah, you can make that argument, but it read as a whole with the statute, it mentions very clearly closet, room, lock or security device to keep it not visible from public view. 99 times out of 100, if not more, if this were litigated, the judge would say you can't do it, okay? So I think this is a pretty clear answer. They cannot do it because of those reasons. If you want, look at 36-2852 for yourself. But having said that, if somebody's growing in their own house and it meets these requirements, yeah, there's nothing you can do. Even if the smell comes out and somebody's concerned about it, we see it more often in a shared wall scenario with a condominium. So that's that, okay? Next question. Well, before we move on, there's a couple more questions here. What's the statute again? So it was the statute of 36-2852. And by the way, this is being recorded and you'll all get a link to the recording. It'll be put back on my website so you can fast forward and zoom in wherever you want to grab the information later. Here's another question with relation to this. So if I see the tips growing over the wall, I can send a violation. Absolutely, you can, in my opinion. And even if you don't, if you've got, there's no dispute that they're growing a bunch of weed in the backyard. I think the statute's pretty clear that they can't grow weed in the backyard where there's an open air space, even if you can't see it. Because we're talking about, the statute's talking about an enclosed room, a closet where you actually close the door, lock it. There's security, like device language in the actual statute. What about in a shed in a backyard? It's a great question. The statute doesn't analyze that. I think that may fall within the statute, and until we have case law that it interprets the statute, it's open for interpretation. So if somebody has a shed or a locked greenhouse in the backyard, chances are you can't do anything about that, in my opinion. But if it's in an enclosed space, that reduces the smell. And also, why are they growing so much? Remember, this is only for personal use. It's not for commercial use. So if they're growing it for commercial use, that's pretty easy to prove. If you only have 2 people living in a home or 3 people. I mean, I shouldn't say easy to prove, but you get my drift. I think if they're growing an acre of weed in the backyard or a massive amount of weed in the backyard, one, it probably disqualifies itself because of the sheer number by the statute, like we said. But 2, there's no protection for commercial use, and therefore you can enforce based on three main provisions in your CC&Rs. Number one, no nuisance. Number two, no modification to the lot without prior approval of the ARC. And number three, no in-home business that doesn't pass the sight, sound, smell test. In this scenario, it might not pass the sight test because you could see it potentially. It probably won't cover the or pass the smell test because you probably smell it. And if they're doing it for commercial use, there may be vehicles coming in and out. Either grab it because they're selling it on property or they're shipping it out. Next question, if there's nothing in CC&Rs or rules, what is the rule for standard for holiday decorations? Okay, I'll get back to that one if we have time. Caitlin, several of these questions in here for me to circle back to what I just said. And so that's why I'm recording this. Please feel free to listen to it again as we move on. And so, yeah, what about the smell of them smoking it? Great question. So before I get to the next question, number three, that's different than marijuana, let's talk about smoking weed in two places, because this is a spectrum of nuisance. So anytime you hear somebody complaining about their neighbor smoking weed or cigarettes or whatever, smoke, whatever, right? You have to discern whether it's a neighbor-to-neighbor issue or a community issue. And I put this on a spectrum of, on this end of the spectrum, it's neighbor to neighbor. On this end of the spectrum, it is community issue where the community needs to step up and do something about this particular issue. If it's only one person complaining, typically it's lower on the spectrum. And I usually, like you probably do, tell them to call the police, try to work it out neighbor to neighbor. If it's on this end of the spectrum where, let's say the smoke is going through a shared system, an HVAC, because it's a condominium with shared HVAC systems. You have multiple people complaining, it's damaging common elements. Your vendors are telling you, look, this smoke is saturating the system, it's ruining it. That is, in my opinion, way over here where the community can take steps. And we've already seen that when it comes to cigarette smoke in shared wall condominium context, okay? Where judges have actually ordered people that they cannot smoke within their unit because it impacts the common elements. It's a shared system, so other people can smell the smoke. It's a nuisance, and judges are okay with that. So here's the spectrum when it comes to marijuana. I treat it the same as cigarette smoke in most scenarios because it's legal to smoke either one now for personal use. If you live in a planned community or manage a planned community where it's individual lots and you are sitting on your balcony in your backyard and smoke drifts over the fence and you smell marijuana smoke and you want the HOA to do something about it, that is over here, in my opinion. 99.9% of the time, it's a neighbor-to-neighbor issue. If you're in a shared wall scenario with a condominium and it is impacting more than a couple of people, then you're over here. And I think you can do something about it. Now, the caveat here is, I'm not giving you legal advice about your specific question. I'm giving you general information. So before you pull the trigger on enforcement, just double check with the counsel, whether it's me or another attorney. Double check so you create your safe harbor. Okay. All righty. Very good. Excellent question. Let's move on to the next one. I have an association whose bylaws don't seem complete. They're missing quorum for the annual and special meetings. And you don't see it anywhere for what the quorum is, what the quorum requirements for either member meetings or board meetings. And then, so the question is wondering, how do we determine quorum and do we look at statutes and what statutes do we defer to? So these are if-then questions and we'll tick them off. First, if you asked me to provide legal advice, I'm going to look at the articles too, because articles could have quorum requirements in them for a member meeting or board meeting. And I'd also look at the CC&Rs because occasionally, very rarely, but occasionally they might have quorum requirements in them for just standard member meetings or board meetings. So Once that's exhausted, this question now assumes that none of your documents say anything about quorum. Well, if you're a condominium, it's ARS 33-1249. And that says that quorum is the presence of 25% of the members. And this is for a member meeting, okay? And that's, so it's 25% unless the bylaws provide otherwise. We've already established in this scenario, the bylaws are silent, the articles are silent, everything's silent. So default rule for condos is 25%. There are a few exceptions, but most, generally speaking, that's per ARS 33-1249. Let's switch gears now to planned communities, single family homes. What is the requirement for single family homes? Well, we're not a condo, so we defer to the Planned Community Act. Planned Community Act doesn't mention anything. So then at that point, yes, we do turn over to the Nonprofit Corporation Act, which states that quorum is a tenth. And that statute is 10-3722. So if you're a planned community and quorum, you don't have quorum requirements, it's usually a tenth. If you are in a condo, it's 25%. The caveat is there are a couple of exceptions, which we won't get into now, but that is generally speaking where it's at, where it lands. Now, having said that, another question is, okay, if our documents are silent right now, can the board adopt a resolution that incorporates quorum? And that's a great question. The statutes say, well, specifically the Condo Act says unless bylaws provide otherwise. So a rule is not a bylaw. Resolution of a board is a rule, it's not a bylaw amendment. Now, if your bylaws have a provision in them that allow the board to amend the bylaws, fantastic. Just have the board amend the bylaws. If the bylaws don't mention quorum, and they require membership vote, usually it's we would defer then if it's a condo 25%, and usually it's simple majority of 25% to amend a quorum, which is usually a super low number. So if you're really worried about this, the first thing I always try to do is, yeah, okay, here's the Band-Aid, here's what the statutes say, but it's a good idea for clarity's sake to amend your bylaws to include the quorum requirements so that this doesn't happen again, or so that a future board doesn't get confused and muck things up. But yeah, the statutes are there to help protect you, and you can rely on those in the absence of language otherwise in your docs. Okay. But again, the tricky part here is determining which one applies, because it's 25% in condos, it can be 10% in planned communities, subject to a few exceptions. Okay, here's another one. It's piggybacking on the first question. In this scenario, the bylaws and none of the other docs state the requirements for amending the bylaws. Now we're talking about amending the actual bylaws, okay? The statute's a little fuzzy to me on this, meaning this is the question, not, so this is what the manager's saying. Statute's a little fuzzy to me on this. Would it be the same 10% membership vote to amend? Or can the board amend if it is silent? So again, it depends on if this is a condo or planned community. That's number one. Number two is the Condo Act has a limit on the percentage of member approval. It cannot be less than 2/3. So we would say to defer to that. Any CC&R bylaw amendments should be approved by at least 2/3 owners if there's complete silence on this. And again, we're under the Condo Act right now. Now, switching gears to the planned community, there's no similar requirement in the Planned Community Act. If it's a single family community, then so a good rule of thumb here is to use 51% member approval, simple majority. Now, going back to the condo for member votes to amend the bylaws, I have had a bit of a legal debate with colleagues of mine at other firms when we go out to dinner or whatever at law conferences about some things. One of my friends would say at another firm, I won't mention who, but he would say that even in condos, it's 25% quorum, but it's simple majority to amend the bylaws if everything's silent. You heard me say it could be 67%. That's the more conservative rule. If you want to get a little more aggressive and cowboy up a little bit, you know, there are the arguments that a simple majority of 25% for condo too. But we don't have case law on this yet, right? So if the board's okay cowboying up a little bit, I am too. Just note that there's a little bit of risk if it's challenged in the future. Because ultimately, if it's challenged, what does a judge normally do? And judge is normally going to tell him to do it over again. Because that caused some problems, maybe. I don't know, I'd have to depend on the facts of what's been done up to that point. But if, let's say, you are amending in a quorum requirement for the board and the judge says do it over again, does that mean all the prior decisions that the board made under that quorum requirement are now void and unenforceable? I mean, judges typically don't want to unwind a whole ton of association business. So that's a very powerful point in our favor, to argue that even if a judge were to order that it be a do-over, we shouldn't be unwinding all the board decisions leading up to that point. Okay, very good. I've got time for one more question. I am barely through this list, so what I'm going to do is we will conclude, because I promised everyone it's 30 minutes. And for our CMCA classes, it will go much longer for you for your hour. But I'm going to record the answers to the remaining of these questions so that when we send out our follow-up to you, you'll get not only this link for what we talked about today, but you'll get the rest of the questions if you want to listen to them, especially if you didn't hear an answer to your question. So let's conclude on this question. A new board member of mine, this is a good one to conclude on. A new board member of mine has been approving ARC items that are clearly stated as not allowed in the CC&Rs. An example is a propane tank that should be buried or screened is not and can't be visible. They have under the CC&Rs, quote, broad interpretation provision, but then can they interpret something that clear? And what are the ramifications of allowing these items? I have the non-board members complaining about them. So worst case scenario, please. Well, first of all, if only one board member is approving ARC items and they either aren't on the ARC or there is an actual ARC, that's a problem. It needs to be an architecture review committee decision, not a board member decision, because that's what the documents always say, is the architecture review committee gets to approve or deny. So if you have an individual board member doing this, it can become a problem, especially if the rest of the board isn't aware of what's going on. And the committee, whether the committee is a separate group of people or the committee is also the board. If they don't know what's being approved or not, and you've got one person doing it, that is a recipe for disaster. So let's get into this worst case scenario situation. Before we do though, one, this is what I'd be thinking through in my mind. One, do the CC&Rs contain any variance language? The reason why I ask that is, let's say that this new board member approves a catastrophe and the person completes it, and then you get a complaint from the neighbor that this nasty big project needs to be removed because it violates the CC&Rs. We've had this happen before. What do? One of the potential ways the board, it's kind of the get out of jail free card, maybe a variance provision in your CC&Rs that allows the board to grant a variance from violations of the documents. So that's number one. But then I would come down hard on the board, especially the individual that is making these decisions, that they have to comply with their fiduciary duties to the corporation. Because there's all sorts of breaches when you act rogue like this. And if a lawsuit were to arise, that individual board member may have to reach into their own pocket for defense if they don't listen to their professionals, including you, when you tell them that. And put it in writing, by the way. Sometimes the documents aren't specific, however, about under what conditions the board can allow a variance. We all know from this scenario, the board's is open to liability. And it's not a good case against the association. So if the board and the manager are aware of what's going on, my strongest advice to all of you is to nip it in the bud right now. The next question is how. Training is great. If they're a current client of ours, I offer an hour training a year for free, no charge. If they're not a current client, it's just my hourly rate, but that's money well spent to get an attorney, their attorney in there for training. And it's pretty easy to do and easy to throw in these points under the fiduciary duty analysis, because there are always going to be updates to the fiduciary duty laws, and I can throw in cases. Now, here's a worst case scenario. In this specific example, I mentioned this about this monstrosity. Let's assume the monstrosity is this huge sports court that is about 2.5 stories tall with massive floodlights in a small tract home community. So the backyard literally is nothing but this sports court. And every evening there's people coming and going. The owner of the property is actually a coach. So they're out there playing basketball every evening till 10:30, 11 at night. You're going to have lots of complaints. You're clearly probably getting, especially whether it's light intrusion, whether it's noise intrusion, you name it, cars coming and going, filling up the streets. To make matters worse, the streets are narrow. So when all the cars pack both sides of the street, you're worried that emergency vehicles are whether they're going to make it through. So you're going to get all sorts of complaints. The big question here is, it was approved in writing. Yeah, it was approved by one person, but it was approved. So is the judge going to order that person to remove the sports court? Probably not. Maybe, but probably not. It depends on if was the owner of the lot and the board member that approved it in cahoots. If that's the case, then yeah, a judge could order him to remove it because it was an intentionally malicious act. But if it was acted in good faith by the owner, board members can make affirmative statements on behalf of the association. This is why it's so important that a board not act outside the scope of what the board members as a whole have approved, and not act outside the scope of what the CC&Rs actually say. So a board member can't approve a committee request. That's a committee function. So all sorts of problems with this. And I would hate to see this in court. I wouldn't want to defend it. Would I defend it? Yeah. But the board needs to go with both eyes, go into that hearing with both eyes open, saying it's not a good case. And there may be some individual liability, especially if that board member has been told not to do it, they continue to do it. Or if the board itself knows the guy is doing it and they don't stop it, then the board could be faced with liability at that point too. So get it nipped in the bud. All righty, very good. Well, that concludes our questions for the day. Thank you so much for everything. I know that we just admitted one other person. Here's the deal though, if you came in late or if you want more, you're gonna get it, I promise. I have 1, 2, 3 more questions that I will answer. So there'll be 2 links that go out. There'll be a link to attend this meeting and watch it if you want. To scroll back to what we said before, get the statute numbers, share it with your friends who have same questions. And then I'm also going to send a second link with the next line of questions, just so you know. I'll read those questions real quick so you know what's coming up. Can and or how can the community regulate short-term rentals if the documents don't mention it? Constant questions. So we're going to talk about how to prohibit short-term rentals. We're going to talk about amending those, and we're going to talk about and answer what the arguments are in condos. I don't know if any of you heard some of the attorneys arguing that it requires unanimous consent to amend short-term rentals. Our position is no, and not only no, but hell no, it's just the 67% or whatever the documents say. And the great news is we have some case law now on that. I'm going to get into that for you for question number 6. And then another question we had is, I have an HOA that's very big on holding community events. My board president wanted information on the legal guidelines regarding COVID. I understand that when the pandemic began, there were issues in terms of HOA's liability, especially because it's not covered under HOA insurance. Where is the industry at regarding COVID and liability coverage? So that is also going to be addressed on COVID liability for HOAs in Arizona. I'm also happy to address a few of these other questions in the chat bar that we have today. I've got some notes for some of you that asked some questions, and I'll piggyback those on at the end. So, hello. Okay, so I promised you part 2 of the Q&A since we ran out of time. Let's just dive right into it, shall we? The first question deals with a piggyback to what we just talked about. That is COVID. So here's the question. I have an HOA that's very big on holding community events. My board president wanted information on the legal guidelines regarding COVID. I understand that when the pandemic began, there were issues in terms of the HOA's liability, as it was not covered under HOA insurance. Where is the industry at regarding COVID and liability coverage? And are there any factors that an HOA should consider when holding a social event? So I'm going to raise 2 points. First of all, in April 2021, there was a law passed that helps shield liability for nonprofit businesses and for-profit businesses. It says basically that if a nonprofit business is acting in good faith, it won't be liable for injury, death, or property loss. Okay, that's number 1. Number 2 is Governor Ducey signed into law the statement that it's very, 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 very to the 10th power difficult to sue a business, including nonprofits, for COVID. And my last point here is, even if there weren't these laws that were just adopted, can you prove that COVID caused damages? Now, in order for me to sue an association, let's assume that I am the spouse of a deceased wife who died because of COVID, and that she got COVID 2 weeks after our big Christmas party that was in the common area. So I go talk to an attorney because I'm grief-stricken, and the attorney gives me this great idea to sue my association for her COVID. I have to claim that, or I think that it was that party, because there were a couple of people that were there and they got COVID after too. So I'm going to assume that that's what caused it. In order for me to maintain a claim against the association, this goes for anything, by the way, if you're injured. So if you're in a car accident and you sue the person for injuries, it's negligence. That's the claim. And negligence has certain elements or required ingredients, just like a cake would. One is that a duty is owed to the individual, like a duty to protect them from something. If it was a car accident, if I'm the driver that slammed into you, I have a duty to drive my car within reasonable speed limit and to keep control of my vehicle. A duty not to drink and be DUI. I breach my duty if I slam into you and it's my fault, because any driver owes a duty to other drivers to drive safely. Okay, so that's duty. You have to have a duty. In this scenario, the duty would have to essentially be that the association has to protect residents and others on its property from COVID. That's number one. Number two, the duty has to be breached. So in other words, in the scenario with the car case, I have a duty to protect you as I'm driving. I have a duty to drive reasonably and not hurt anyone. But I breach that if I slam into you, DUI, right? So I breached my duty. The next one is that breach has to cause the damage you complain of. And then the last element is that there has to be damages, and damages are monetary damages. Sometimes if it's a horrible scenario where I acted just horribly, evilly, if that's a word, but if I acted with evil mind, that's called punitive damages. They're meant to punish me for the way I acted. But actual damages are hospital bills, pain and suffering. Those are some of the more realistic damages we know about. Here's the problem with COVID. If I'm trying to sue my association for COVID, how in the world can I prove that any breach, assuming there was a breach, and even assuming there's a duty, because those are debatable, but how can I prove that it caused the damage complained of? In order for me to prove that, I essentially have to say there was zero exposure, period, during an open window of a pretty big period of time. I never touched anything. Basically, I lived in a bubble. Literally, I lived in a bubble. No one brought me any food. I didn't go to a supermarket. Zero. That's almost impossible to prove. I'm going to go out on a limb and say, I think it's impossible, period, but it's an absolute. I don't want to use the word absolute. So what's the state of affairs with COVID? As far as COVID itself, I think the liability is very low for an association for the three reasons we just talked about. When it comes to insurance, you check with your adjuster on that. This is such a new scenario where I really haven't had to deal with insurance with respect to defending an association for a claim or covering for COVID coverage because of these three main reasons. I think at the very beginning of the pandemic, everyone was starting to wonder what this means. But now that we're sitting here 2 years into it, I don't think people are as worried from a liability perspective for the main reasons I just gave you. So great question. Okay, now let's talk about the next question, and this is short-term rentals. Can the community regulate short-term rentals if the documents do not mention it? That's number one. And number two is, can the documents be amended to prohibit short-term rentals or regulate them? So let me answer the first question. Very easy. No, the HOA cannot regulate or prohibit short-term rentals without that provision being in the CC&Rs. It cannot be in a rule. It cannot be in a board resolution to be enforceable. It must be in your CC&Rs. It must say something specific, essentially, like shall not be less than 30 days. Okay. Some of the older CC&R provisions say can't be transient rentals. I'm okay with that because this code for various states or cities, define transient as not less than 30 days or 20 days, but the industry standard is not less than 30 days. Okay. And we've been able to, in court, enforce the short-term prohibition in the CC&Rs against somebody who was doing Airbnb when the CC&R said no transient rentals. Obviously, not less than 30 days is better than just saying transient, but you get the drift. So answer number one, no, you cannot prohibit short-term rentals right now under the current state of laws in Arizona unless it is in your CC&Rs. Oh, by the way, if you want the statutes for that, it is ARS for condos, ARS 33-1260.01 subsection A. And for planned communities, it is 33-1806.01 subsection A. Both of them are very clear. You have to have that provision in what the statute says, quote, your declaration. And if you turn to the declaration definitions, that is your CC&Rs. So that's answer to question number 1 of this 2-part question. Question number 2, can the governing documents be amended to add language to prohibit short-term rentals or regulate them? The answer is absolutely yes, but let's dissect this into two parts. Part number 1, planned communities. Yeah, go for it. You're good. Do it. You'll be fine. Record the amendment once it's passed. Work with myself or another attorney on that amendment process. Get it passed, get the CC&R recorded, and start enforcing. Now we're going to talk about condos in a minute because it's not so clear in condos, but we're for planned communities and condos when it comes to enforceability. Once the CC&R provision amendment is recorded, questions come up, well, can I enforce it against all the rental agreements that have entered on Airbnb? And the answer, in my opinion, is no. You can't demand that the unit owner or the homeowner that entered into a bunch of Airbnb contracts for the next year or two has to terminate all those contracts that have already been paid for, already in the books, because that would be a retroactive application to what was legally entered into at the time. So it's my opinion, there's no retroactive effect. You can only enforce the CC&R amendment for short-term rentals moving forward, and you have to honor those. Now, that doesn't mean that owner can keep entering into short-term rentals. Once the CC&Rs are recorded and in effect, they have to stop, but you have to allow them to honor those that were already in existence prior to the amendment. Okay, simple enough. Now let's dive into a deeper question. Ironically, I don't know if you know the attorney, but Mark Bainbridge, he's a homeowner attorney. He sued one of our clients recently for amending their declaration, i.e. CC&Rs, to prohibit short-term rentals. His argument is that it requires unanimous consent, okay? Because it's a, quote, change of use. Let's talk about this for a second. Some of you may have heard this argument, some of you may not have. So let me just explain it for a second, so we're on the same page. First of all, if you're condo, there is an amendment statute. It's 33-1227. 33-1227 starts with a baseline rule of you can amend the CC&Rs with 67% approval of the members, okay? So it goes on to say, however, that if you amend the CC&Rs that changes the use of a unit, that requires unanimous consent of all the members in the community. And in this scenario with this particular client, the association got their requisite 67% approval, recorded the amendment prohibiting short-term rentals, and they were just served with a lawsuit from a unit owner that does short-term rentals there, claiming that the amendment is invalid and void because unanimous consent was not received. I mentioned in the last class with us in the Q&A session that there's a case on this issue, and there is. It's in the context of planned communities, but it's very relevant here. The question really is this a change of use? And what we get out of that other case is a rental amendment to the CC&Rs is not a change of use of the unit. Hence, we default to the percentage requirement of 67%. It doesn't require unanimous consent. So that's number one. Admittedly, this case may go to the Court of Appeals. I don't know if it will or not. I'm guardedly optimistic that we will win this case, or the insurance attorneys, whoever they may be, because of the recent case in planned community context. But there's always a risk that it won't, and we don't have clarity yet for condos until the Court of Appeals rules. Frankly and selfishly, I hope this case goes to the Court of Appeals because I think the facts are great, and I think the law is great and plays in our favor. And I'd like to have the Court of Appeals clarify these arguments. So we're all clear that an amendment in a condo to prohibit short-term rentals does not require unanimous consent. A couple more arguments for you as to why I think it doesn't require unanimous consent. One, I think change of use of unit goes to code restrictions, that kind of thing, municipal issues, redefining, especially because when you read this, it's like change of the unit boundaries, which would basically change the plat, big things. But not only that, but if you look, like we just said in the first part of this question, the Condo Act 33-1260.01 subsection A expressly authorizes the association to prohibit or restrict short-term rentals if it's in the declaration or amended into the declaration. It would be impossible, flat out impossible, to amend a short-term rental provision into the declaration if you require unanimous consent. Why? I think it's obvious. You're wanting to amend a provision like this into the CC&Rs because somebody in your community is doing it. And if they're doing it, they're not going to say, hey, shame on me. I'm not going to approve. I'm going to approve this and prohibit myself from doing it. So there is case law out there that says that if an argument as to statutory interpretation leads to absurd results, it shouldn't be interpreted that way. So we have 33-1260.01 authorizing short-term rental regulations for a reason. It's right there. And if unanimous consent was required, we'd never be able to rely on 1260.01. So I think the arguments are very strong. We've already won the issue in the planned community context. Now it's just time for us to win it in the condo context. When I say us, I mean us as an HOA industry. So there you have it. Those are the two questions I wanted to cover with you. Thank you so much, and happy managing. Bye-bye.